One area that I find business owners have many questions about is, how can I protect my business information? I've worked really hard to build this business, and I've come up with some techniques that not everyone has. How can I keep my employees from taking all the training that I've given them and going out and competing with me? And there actually are very concrete steps that you can take to prevent your information from walking out the door. Some people believe that confidentiality agreements or non-compete agreements are not enforceable, but that's really not true. Especially in Texas, recent court decisions have reinforced the fact that a valid, well-written, and limited non-compete can be a great tool for employers. So let's talk through some of these agreements that you may want to consider having with your employees. A confidentiality agreement is probably the simplest of these documents. That is an agreement with your employees that they will protect the confidential information that you've developed within your business and that they've had access to as your employee. These agreements can be signed by every employee, every contractor. There's really no limit on that, and they're perfectly reasonable. It's something that simply says the employee will only use the information you give them for the benefit of your business, not for another business or not for their own business that they may go and set up at a future date. Another type of agreement business owners should consider is the non-compete. These agreements get a bit more complex because you have to have them carefully written so that they're not too excessive as far as the scope of the activity that you're trying to prevent, the time period, the geographic area where you're trying to prevent competition. Those are items that the courts would look at if you went to enforce a non-compete agreement. But again, they are enforceable if they're written correctly and within the law. A third type of agreement you may want to consider is the non-solicitation agreement. And this agreement is really designed to prevent one of your employees from leaving your workforce, going out, setting up a competing business, and coming back to raid your employees or your customers from you. These agreements, for example, would say, from 1 year from the date that you leave my employment, you will not contact the customers that you had contact with while you were with my business. So it gives a little space, a little time before the person can compete with you. And again, these are valid as well if they're properly drafted. You may be asking, how do you enforce one of these agreements? Well, usually a non-compete or a non-solicit is enforced by going to court and asking a judge to grant you a TRO, a temporary restraining order. And then you have a certain amount of time to go in and get a temporary injunction until the case can be tried in full before a judge or a jury. So it is a bit involved to enforce these agreements. What I tell my clients is that one of the main benefits of getting a confidentiality agreement, a non-compete, or a non-solicit is that it tells the employee that this business is serious about protecting its information, that it's taken the time to get these agreements in place, and that this business will enforce its rights to protect information. So it's a psychological benefit to the business because it really tells your employees you're serious about it and makes them think twice before they go out and set up their own business or take your clients with them. So even if you never go to court to enforce one of these, having that written agreement on paper brings an agreement between you and your employees that can really prevent a lot of these problems in the first place. Just quickly, I'm going to talk about promotions and terminations. I'm not going to spend a lot of time on this, but some of the same pointers that we talked about in hiring apply here too. You want to do all that you can to keep your promotion decisions objective. And one reason that this has been brought to mind recently is that there's been a recent U.S. Supreme Court case called Ledbetter. Some people have heard of it, many people have not. But the reason it's important is that the Supreme Court recently decided that even if a decision affecting someone's wages happened many, many years ago, that can still be brought into consideration and into the calculation of that person's damages. Let me tell you just a bit about Lily Ledbetter and what happened to her. Ms. Ledbetter was a manager at Goodyear Tire for her entire career. About 20 years prior to the time she filed suit, she was given raises based on manager evaluations. That's how Goodyear did their raise analysis. And so for 20 years, she did receive raises. She did receive increased compensation as a result of the evaluations. But when she got close to retirement, she discovered, or she felt, that many of her evaluations had been not as good as her male counterparts, not because her work had been inferior, but because she was a woman and her counterparts were mostly men. She was able to go to a jury and convince a jury that that is indeed why her raises were smaller for her entire career. And she was awarded a multi-million-dollar award based on that. Now, the question was, did those pay decisions that happened 20 years ago and that happened throughout her career really fall within the very narrow time period that's usually allowed for bringing a discrimination claim? Usually you have only 180 days, or in some cases 300 days, to bring a claim of discrimination. Well, she was talking about events that happened 20 years ago. This case went all the way to the Supreme Court, and the Supreme Court decided, yes, if it's an ongoing act of discrimination, we are going to allow people to look 20 years back. So what really happened here is there was a snowball effect. Even though her difference in wages 20 years ago was very, very small, it had snowballed over the years of her career, so that at the end of her career she was making significantly less than her male counterparts who had started in the same position. So that's just a warning that even the smallest of differences can really snowball on you. And over the course of time, if you have an employee who has been getting slightly lower raises or fewer promotions, it may not seem like a big issue when you're looking at that exact decision, but you've got to look at the effect over time, because that's the new standard for how these kinds of claims are evaluated.